In a unanimous decision issued on June 29, 2023, the United States Supreme Court discarded decades-long precedent by strengthening legal protections for workers whose religious beliefs conflict with their job obligations. The ruling in Groff v. DeJoy is expected to significantly impact job opportunities for Americans of various faiths who have frequently faced challenges due to their Sabbath-keeping practices. The legal team representing Gerald Groff included Adventist attorney Alan Reinach, who serves as Director of Public Affairs and Religious Liberty for the Pacific Union Conference, and the Executive Director of the Church State Council. I had the opportunity to sit down and talk with Alan following the June 29 decision.
So the case is an issue that we've been working on literally our entire career for like 3 decades, and it has to do with the standard for employers to deprive people of faith of religious accommodation. So, for example, for Seventh-day Adventists, our big issue is observance of Sabbath, right? Well, this was a Sabbatarian case that went to the Supreme Court. It just wasn't our Sabbath. It was a very fine Christian gentleman who lost his job with the Postal Service because he doesn't work on Sundays. But the issue is exactly the same as it would be for Seventh-day Adventists, which is, how much of a hardship on a company justifies their denying an employee their day off, their religious day off. And previously, for decades, for 46 years, the standard was not much, bare minimum. And obviously, the phrase that Congress enacted, which is undue hardship, doesn't mean not much, right? It doesn't mean bare minimum. But we couldn't get Congress over many decades to reevaluate. They adopted different standards in other statutory schemes, like the Americans with Disabilities Act. But finally, we got a case before the court, a clean case for them to decide, okay, what does undue hardship actually mean? And they said it means what it says. It means a hardship that's unacceptable, that's too much, not bare minimum. And it was a fantastic win, and it was a 9-0 win.
And this now sets a precedent, correct?
It sets a precedent not only for future cases, but for any pending cases as well. And there's plenty of cases pending because they're just saying this is what the standard is and has been, that the courts have been misunderstanding the case that they're relying on for the de minimis test.
I also talked by Zoom with 3 other individuals involved with religious liberty for the Adventist Church. Bill Knott, the Associate Director of Public Affairs and Religious Liberty for the General Conference. Bettina Krause, the editor of Liberty Magazine, and Orlan Johnson, the Director of Public Affairs and Religious Liberty for the North American Division. They shared why this case is so significant to the Seventh-day Adventist Church and what we have learned from it.
This is where a bit of history helps us. 46 years ago, a Sabbath keeper by the name of Hardison brought suit against Trans World Airlines, asking that his Sabbath behavior, belief to keep the seventh-day Sabbath, be accommodated by his employer. The case wound its way all the way to the Supreme Court. And the Supreme Court in 1977 took what almost everyone today would call a very unfortunate decision. They basically said that all an employer has to do is to show that they would suffer any level of hardship. They called it the de minimis standard, the way it's been termed. Basically, it's inconvenient to accommodate this person. Might cost us a few dollars to accommodate this person. And the businesses have used that for more than 4 decades to routinely dismiss the requests from Sabbath keepers and other people of other faiths about their beliefs for accommodation in the workplace. So this was the chance to review and, frankly, fix the record of Hardison.
It is a breakthrough for the Adventist Church because it's something that we've been working for more than 4 decades. It's something we've been praying for. As you know, so many church members through the years, they've had stories of being demoted, of not being hired, of losing the opportunity for promotion simply because their employer had no legal incentive to take their requests for Sabbath accommodation seriously. But the court in Groff has made it crystal clear that employers now need to take requests for religious accommodation seriously. They can't just brush them off. And I think it's also important to note that this is not just a win for Seventh-day Adventists. I mean, this is something that is meaningful for every person of faith in America, especially religious minorities, such as a Muslim woman who wears hijab, or a Sikh man who must wear a beard in the workplace, or a Jew who also needs Sabbath accommodation. This is an important decision also for them.
Well, one of the reasons it's so significant is because the Adventist Church for a long time has really spent a lot of time looking and working on issues regarding religious freedom for all, not just Seventh-day Adventists, but we've done a lot of work representing other religious groups, and other religious groups have learned to depend upon the Seventh-day Adventist Church. Even this particular case in Groff, it was the Seventh-day Adventists working in the Pacific Union that first got the call about this case. So it just kind of goes to show what our reputation has been, what we've been looking to do. But it's one of these things where we, in particular in the area of religious freedom, we have to look at it from the old concept of injustice for one is really injustice for all.
It's the culmination of these decades of efforts. I happen to have the privilege of being in the right place at the right time. And frankly, it's an answer to prayer, because I prayed several years ago, Lord, let it be one of my cases that goes up. And that prayer got answered. But, I also have a lot of cases. So, there's that too. But I'm grateful. I don't think our church members really understand the value of these interfaith friendships. Our motto in religious liberty is making friends before we need friends. And somehow we have to get out of this us against them, sort of cultural cocoon where the way we relate to people of other faiths is simply to look at the differences. I just think we need an attitude adjustment and to appreciate the work that the Public Affairs and Religious Liberty Department does in building these bridges of friendship. This case is certainly a payoff of all of that.
I appreciated hearing the answers about what we as a church have learned from this landmark case.
I think, in a word, we've learned perseverance. I mean, we have been fighting this issue since the early 1970s. And through the years, we have brought case after case, and every time we've gotten close to the Supreme Court, it's been knocked back. But we've not given up, and our church members have not given up. Every person who has brought suit to protect their rights in this area, I think, is a hero, because they have chosen to fight this at great cost to themselves and sometimes to their families, because it is a matter of principle. So I think as a church, we've learned that, we can work together with other religious groups on common goals, but we've also learned, again, the principle of perseverance.
People would say, well, after the Groff case, then that means it's all clear now. Actually, it's still going to be a little bit muddy as we go through this process, because we have to really learn the specifics of what things mean from a legal perspective. For a long time, the Hardison case was talking about undue hardship with no real definition. But one thing that this case particularly did was to make clear that the hardship has to do with the employer as opposed to the employees that also work at the organization. So that when someone comes and said, I have a problem in the workplace, you can't come with the argument, well, this causes my other employees to be uncomfortable, or this causes my other employees to have to, quote unquote, take on more of the workload. And I think that clarification has given us a step forward. But I think we're still going to be wrangling a little bit, because at some point we're going to start hearing more about sincerity tests. We're going to start hearing more about, who's real and who's not real. And I think in particular with this case, because you're talking about having the Sunday off, there's probably about 180 million Americans that have some type of religious connection to Sunday. And if all of those groups decide that we've got large masses that are asking for that day off, there probably is going to be some economic development impacts that come into play. and we're going to see how it all plays out in the end. So, on one hand, it's a great decision, but on the other hand, it's still a whole lot of moving parts.
What do you believe we as a church, as a Seventh-day Adventist church, have learned from this case?
Persistence.
Persistence, okay.
This is, I think, the key lesson that I've extracted from this. To realize that for dozens of years, Adventist attorneys have kept working, have kept churning in some cases to bring these cases forward. By God's grace, the perfect case came along, and it didn't happen to be a Seventh-day Adventist. It was a devout person of another faith whose Sabbath for him is fully as meaningful as ours is to us. That, in many ways, the lesson of persisting in these legal struggles is, for me, the key thing I have focused on. And really often in almost every process-oriented situation, like government, legislation, and law, persistence wins.
Yes, persistence certainly paid off in this case. And building the bridges of friendship with so many people of different faiths that Alan discussed is what the Public Affairs and Religious Liberty Department is all about. Thank you, Alan Reinach, Bill Knott, Bettina Krause, and Orlan Johnson for taking the time to discuss this important case with me. And thank you for joining us today. There are many helpful links and resources in the description box of this video. For the Pacific Union Conference, I'm Connie Vandeman Jeffrey.